Welcome, everybody, and thank you for joining Seyfarth's webinar, PAGA Discovery, Practice, and Sequencing. All participants are in listen-only mode. If you have any questions during the presentation, please submit through the Q&A chat box section located on the right side of your WebEx window. We will do our best to get to everyone's questions. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of this webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Daniel Wang. Daniel, you may begin.
Hello, everyone. Welcome to the second session of the webinar series, Let's Talk PAGA, Navigating Shifting Case Law, New Theories, and Defense Strategies. My name is Daniel Wang, and I'll be presenting alongside Matt Gooden, who is Senior Counsel in our San Francisco office, and Elizabeth McGregor, who is a Senior Associate also in our San Francisco office. In today's session, we will be covering the unique challenges in handling discovery in PAGA cases. Like all things PAGA-related, the issues are nuanced and constantly evolving. Our goal today is to provide in a 30-minute webinar a high-level overview of key discovery concepts. As Roya mentioned, if you have any questions, please feel free to submit them through the Q&A chat box, and after the webinar, either we or somebody from our team will respond to your questions as soon as we can. This presentation, this screen here just iterates that today's presentation is for discussion purposes only. It is not to be construed as legal advice or a legal opinion on any specific facts or circumstances. So, what discovery to expect in a PAGA case? For the most part, the type of discovery requested in a PAGA case is very similar to the type of discovery you might see in a wage and hour class action. So these include items such as a request for names, addresses, telephone numbers, and more recently, emails of employees who may have suffered any type of labor code violation alleged in the complaint. Plaintiff's lawyers want this information so that they can contact employees to speak with them about their experiences working for the employer and to identify potential witnesses for trial. Another item that you can routinely see in a wage and hour class action as well as a PAGA action are a request for employers' policies pertaining to wage and hour practices that apply to the potentially aggrieved employees. This could be anything from employee handbooks, freestanding policies, collective bargaining agreements, and possibly even employment agreements that might exist. Another item that is often requested are time records showing when employees clocked in and out each shift and when they clocked in and out for meal periods, along with a request for pay records or wage statements for potentially aggrieved employees. Another request that we typically see will be information about the composition of the potentially aggrieved employees. So this could be, for instance, a request for the number of employees who worked in the state of California during the relevant time period, the number of pay periods that potentially aggrieved employees work, since PAGA penalties are assessed on a pay period basis. The job positions that the potentially aggrieved employees held, how much variation there may be among the employees, and maybe even the number of shifts that employees worked per pay period under the theory that the more shifts an employee works in a pay period, the more likely there may be violations that occur during that pay period. And of course, there is the request for a person most qualified deposition in state court or a Rule 30b-6 deposition in federal court. So in today's session, what we will be discussing are ways that these same type of discovery requests in PAGA cases are handled differently than in wage and hour class actions, and potential ways to limit the breadth of discovery in a PAGA case. I will turn this now to Elizabeth, who will begin by discussing the request for contact information.
The leading authority addressing the discovery of employee contact information in the class action context is Belaire West versus Superior Court. In that case, the court noted that employees do have a privacy interest in their personal contact information, including addresses and phone numbers. The court noted that that information had been given to the employer as a condition of employment, and that employees could reasonably expect that that information would not be shared with other parties except as required by government agencies or benefits providers, and that that expectation was reasonable in light of the employer's usual confidentiality practices. But the court also found that there was an interest in disclosing the information in discovery. The court explained that current and former employees are percipient witnesses of the employer's employment and wage practices, and as such, their contact information is appropriately discoverable. And the court also explained that those competing interests between privacy and discovery needed to be balanced. And in considering those issues in the context of that case, the court found that distributing notice to employees before their contact information was produced, giving them the opportunity to opt out of having their information disclosed, adequately protected the employee's privacy interests. In the notice that was considered in Belaire West, that notice advised current and former employees of the lawsuits and its allegations and explained who could be a member of the proposed class. The notice also informed employees that plaintiff's counsel wanted their contact information to discuss the lawsuit with them, and it included contact information for plaintiff's attorney and informed employees that they were under no obligation to discuss the case with either plaintiff's counsel or counsel for the employer, and that they could choose not to have their information disclosed if they wanted to, object on privacy grounds. Given that courts do routinely approve disclosure of contact information in the class action context, there are several issues to consider before a Belaire notice is distributed. The first is that once plaintiff's counsel has that information, it's possible that plaintiff's counsel will use the information not for purposes of investigating the case, but to try to solicit new clients to bring additional lawsuits. So one way to protect against that is to have a protective order in place before the Belaire West notice goes out. That notice, the protective order should include a provision that limits the use of contact and other confidential information to purposes of the litigation only and not outside the litigation. Plaintiff's counsel may also seek the disclosure of employee email addresses through the Belaire notice process. Having the email addresses will obviously make it easier for plaintiff's counsel to contact employees. So employers can push back on that by noting that that type of information is generally less publicly available than telephone numbers and as such should be subject to a greater privacy interest and not subject to disclosure. Employers will also want to inform managers before the notices are distributed. Employees who receive the notices may naturally go to their manager with questions about the lawsuit and what they should do. And it's important that managers are prepared to answer common questions that might be raised. And in particular, managers will want to make it clear to employees that there will be no retaliation, whatever the employees choose to do, whether the employee wants to assist plaintiff's counsel in the lawsuit or opt out of having the contact information disclosed. Next slide, please. Belaire West ordered distribution of notices to employees in the class action context, but Williams versus Superior Court also approved distribution of notices in PAGA actions. The employer in Williams had argued there were certain differences between PAGA actions and class actions that militated against disclosure of contact information in the PAGA context. The employer had noted that PAGA does not impose fiduciary duties on plaintiff or plaintiff's counsel with respect to other employees, and that plaintiff's counsel does not represent employees in a PAGA action the way plaintiff's counsel would represent members of a certified class. The employer also argued that PAGA does not have class certification requirements, and as such, there aren't those necessary due process safeguards that absent class members have in the class action context. However, the court found that those differences didn't change the fact that employees in PAGA actions are percipient witnesses, and therefore their information is relevant. The court also noted that plaintiff's counsel and plaintiff has the duty of showing violations, of proving the case, and so plaintiff's counsel has an interest in contacting employees. With regard to the due process issue, the court wrote that PAGA actions don't raise those types of concerns because employees don't own a personal claim for PAGA penalties. So the employee's personal claims aren't at stake. And the court found that the overlapping policy considerations between PAGA and class actions supported extending PAGA discovery as broadly as class discovery. The trial court in Williams had originally granted plaintiff's motion to compel contact information as to plaintiff's store, but he conditioned further contact information on plaintiff sitting for a deposition and showing that his allegations had some merit. The Supreme Court reversed that limitation and instead allowed statewide discovery of contact information. The court also rejected the argument that plaintiff had to make a showing of being an aggrieved employee in order to get contact information. The court acknowledged that lack of standing is a defense to a PAGA action, but said the proper way to raise that issue was to assert it as an affirmative defense and bring a motion for summary judgment rather than trying to resist discovery. And the court also rejected the idea that discovery should be contingent on proof of a uniform company policy. The court wrote that disclosing contact information could lead to that type of proof. So the court summed up its holding by saying that there may be special reasons to limit or postpone a representative plaintiff's access to contact information, but that the default position is that contact information is discoverable. And now I'll hand it over to Matt.
Thanks, Elizabeth. So another crazy PAGA case. I'd probably title this slide in a horrible PAGA case. It's kind of a toss-up between the worst, Huff or Williams. This is yet another case reminding us that PAGA cases are not class actions and that the plaintiff acts as a representative of the state. This case basically holds that a plaintiff has standing to bring a PAGA case if they can prove at least one violation, one labor code violation that's alleged in the complaint. So think about that. Yeah, theoretically, that could mean that all the plaintiff has to do is to prove one single meal period violation during the limitations period. And then they have standing to represent all aggrieved employees in California with respect to any other labor code violations that are alleged in the complaint. And that's the one limitation that Huff mentions, is that the labor code violations have to be alleged in the complaint. But is that really a limitation? No, instead what we found is plaintiffs are using this holding and now they're drafting these kitchen sink pleading type complaints alleging every single PAGA labor code violation they can possibly think of. So that's what we're seeing as a big result of Huff. So what are some things that we can do to start limiting and militating against the holdings in Huff and Williams? Let's take a look at the next slide. So we're getting arguments from Huff and Williams that plaintiffs are arguing Huff gives them an argument that if they establish one violation, then they are essentially entitled to conduct an audit of the employer's entire wage and hour practices. And then they use Williams to argue that they have a right to broad discovery as to time and wage and payroll records for all employees in California. So what can we do to fight against them? Well, here's a couple things to keep in mind about Huff. First, Huff is a case about standing only. It has nothing to do with discovery. It has nothing to do with a motion to sequence discovery under CCP section 2019.020, or nothing to do with sequencing or phasing discovery. Second, Huff makes clear that the plaintiff has to establish that she suffered at least one labor code violation as alleged in the complaint. So it can't be any labor code violation. But as I mentioned before, we're seeing these kitchen sink pleadings with listing every labor code violation under the sun, so that's not really a limitation. The third thing to keep in mind is that the trial court in Huff, Judge Kerwin in Santa Clara County Superior Court, actually agreed to sequencing the PAGA trial in that case. And the first phase limited to a sample of 20 employees. While the portion of that case is dicta and not something that we can really cite, it does at least show that trial courts are open to the idea of sequencing or phasing discovery or trial in PAGA cases. And here's a couple things to keep in mind about Williams. Williams only involved a request, as Elizabeth pointed out, only a request for contact information to send out a Belaire notice. It does not deal with a request for merits-based discovery seeking time records, payroll records, wage statements, and things along those lines. And the court specifically noted in that case that the employer could have, but didn't, bring a motion to sequence discovery or phase discovery under CCP section 2019.020. So if you're bringing a motion to sequence under that section, Williams is not, an authority really that's relevant to the court's decision in a sequencing motion. So that's something to emphasize if you're bringing a motion under Section 2019. And I think with that, I recognize that those are the tiniest of silver linings, but we take them where we can get them. And with that, I turn it over back to Daniel.
Okay, and Elizabeth will now discuss ways to potentially limit discovery.
Yes, so in thinking of ways to limit discovery in PAGA actions, it's important to bear in mind that plaintiff's counsel might try to take advantage of the holding in Huff, as Matt was saying. They may try to essentially use the case to conduct an audit of the employer's wage and hour practices, find something that appears to be unlawful, and really go with that theory. But as Matt was saying, it's important to remember that Huff limited the violations that could be asserted to what was asserted in the complaint. So it's important to really make sure plaintiff's counsel staying within those boundaries and potentially bringing a demur to have plaintiff's counsel more clearly articulate their theory of the case if the allegations are really vague and could be subject to evolving interpretation over the course of the case. Another way to limit discovery is to make sure that any discovery is focused on the 1-year statutory period for a PAGA claim, plus the 65-day tolling period for the LWDA letter. Plaintiff's counsel may argue that they're entitled to discovery beyond that time period in order to show that a practice continued into the statutory period. So it's important to push back on that and try to limit the time period. And then another way to limit discovery potentially is by using a sampling of records to the extent that production of documents or information would be voluminous. If there are quite a few employees at issue, the employer can propose a sampling of records as a potential compromise. But it's important to reserve the argument that any sample would not be statistically significant to potentially raise that down the road. Next slide, please. And another way to try to limit discovery is by curing any violations that can be cured by the procedures laid out in PAGA. And once a violation is cured, the employer can argue that that issue is removed from the case and should not be subject to discovery. One common area where that comes up is with wage statement violations, which can often be subject to a cure. And finally, the employer should consider challenging the evidence that's requested in discovery if it wouldn't show a violation. One example would be if the employee is seeking time records and the theory of their case is off-the-clock work. Time records obviously wouldn't capture any off-the-clock work, so the employer can push back and say it's not relevant and shouldn't be subject to discovery. And now I'll hand it back to Daniel.
All right, so we're going to read the CLE code. It is SS, as in Seyfarth Shaw, 4545. That's SS 4545. One more time, SS 4545.
So now we get into talking about ways to possibly limit discovery and perhaps some creative ways. With all things PAGA, the law is constantly evolving, excuse me, and sometimes creative arguments are necessary to think outside the box. So we start with one possible argument that might work in a PAGA action, which is to recognize that, as the Supreme Court recognized in Williams versus Superior Court, that PAGA does not make other potentially aggrieved employees parties or clients of plaintiff's counsel. Now, unlike a class action, potentially aggrieved employees then are not parties to the action, and the plaintiff's attorney does not represent the potentially aggrieved employees. In other words, these individuals are non-parties to the PAGA action, arguably. Now, if this difference allows a PAGA plaintiff to avoid having to meet class certification requirements, then employers should be entitled to discovery limitations that the Code of Civil Procedure places on non-parties. A plaintiff shouldn't be allowed to use the difference between a PAGA and a class action as both a sword and a shield. And the Code of Civil Procedure has a specific provision when it comes to seeking employment records of non-parties, and that is Section 1985.6, which defines employment records as among other things, including information pertaining to the employment of any employee maintained by the current or former employer of the employee. Now, under 1985.6, what somebody seeking employment records needs to do is serve a subpoena on the employee or current or former employee whose records are being sought. The employee can then serve objections or file a motion to modify the subpoena. And then if the employee either serves an objection or files a motion, then the employer doesn't need to take any action until the objection or the motion has been resolved. Now, the key benefit of this argument, the argument being that a PAGA plaintiff, if they want time and pay records of potentially aggrieved employees, that they would need to comply with Section 1985.6, is that this process is incredibly time-consuming and expensive. And it would be highly unlikely for a plaintiff's attorney to go through the effort of seeking records through a subpoena for all potentially aggrieved employees, especially if the action involves a couple of thousand potentially aggrieved employees. So the benefit of this is that if your arguments prevail, that essentially it would limit the plaintiff's counsel's ability to obtain that information just by way of how expensive that process would be. Now, the argument we usually will see in response to such an argument as that would be, well, the privacy interest, which is what 1985.6 seeks to protect, can be accomplished by redacting the records. Well, the redacting the records could be incredibly time-consuming, especially for dealing with manual records, and there might be other information that may not be redactable that could lead to the discovery of who that individual might be. For instance, instead of an employee ID number, there might be partial Social Security numbers on wage statements or time records. And so that redaction wouldn't necessarily completely eliminate any risk of invasion of privacy. Now, this argument is far from clear that it would work. It has worked in front of some courts, but it's an example of the type of maneuvering and creative arguments that one might need to come up with in combating widespread discovery and broad discovery in a PAGA action. In addition to limiting the scope of discovery, another option is to consider seeking to phase discovery. In a class action, discovery is usually phased where the first phase deals with class certification issues, for instance, and if the class is certified, then the second phase would deal with the merits. In a situation where a plaintiff has brought a hybrid class and PAGA case, then it's possible that the court might be more open to phasing discovery in the PAGA case to track the class action. An example might be that, let's assume a plaintiff worked in a single branch or a store. The employer is challenging that any issue that the plaintiff might have experienced is limited to that branch or store where the plaintiff worked. And in a class action, that argument might prove successful. The court is required to balance the need for the information as well as the potential abuse of that discovery, and the court may very well limit the discovery to the single branch or the store where the plaintiff worked, unless the plaintiff can provide facts supporting a company-wide policy and practice of violating the law. But in a PAGA action, the court may simply say, since there is no class certification requirement, if the plaintiff is asserting of a meal period claim, then the plaintiff should be entitled to the merits discovery on the meal period practices throughout the entire state of California, not limited to just where the plaintiff worked. But if you're in a hybrid case, then you have the argument that, well, this would be both cumbersome and inconsistent to allow class certification discovery to proceed as to the class allegations, but then merits discovery to proceed on the PAGA allegations. And oftentimes, the PAGA allegations and the class action allegations are the same. So in that situation, a court might be more inclined to just focus on class certification discovery and then phase the PAGA discovery to until after the class certification decision has been rendered. But even if it's a PAGA-only action, you can still make the argument that there's judicial economy concerns that might warrant phased discovery. So one thing that both a PAGA action and a class action have in common is that the plaintiff has to have standing, either to bring the class or the PAGA action. So an argument that could be persuasive to a court is that the court should first allow discovery to determine whether the plaintiff even has standing to bring the action. So this argument might be more persuasive if there is something unique about the plaintiff. It might be a very short duration that the plaintiff worked, or there might be other unique facts that would render the plaintiff very different than any other employee that might be part of the potentially aggrieved employees, and that the argument of promoting judicial economy could be persuasive to the court in that situation. I'm going to now hand it over to Matt to discuss certain factors to consider when seeking to phase discovery.
Thanks, Daniel. I think the first thing to keep in mind when you're talking about sequencing or phasing discovery is, while it is an uphill battle, it can be done. We've had some specific examples in our firm just recently. Late last year, in a garden variety meal and rest period and off-the-clock work case, we first asked Judge Chow in San Mateo County Superior to limit the Belaire notice to employees that were just in the exact same position as plaintiff. She was a receptionist. He denied that based on Williams. After the notice went out, plaintiff predictably sought the time, payroll, wage, and hour records for all employees in California. And so we filed a motion under Section 2019.020 to sequence discovery and trial, and asked that the judge limit both of those to the issue of whether plaintiff could prove that she suffered at least one violation alleged in the complaint. And Judge Chow granted that motion. So now we basically have discovery and trial limited only to the issue of whether plaintiff herself and plaintiff only can prove one of the labor code violations alleged in the complaint. Another colleague in our LA office just last week prevailed in a motion to at the Belaire level. The court agreed with their request to phase discovery under Section 2019.020 and to limit a Belaire notice to just 50 people who worked in plaintiff's group and not 3,500 employees California-wide. He agreed with their argument that if the plaintiff can demonstrate why another Belaire notice might be justified or broader discovery justified at some later point, they could come back with evidence and try to make that case later. So some strategies to keep in mind. First, think about the type of case you have. This isn't going to work in every case. It's not going to work in a case where, as has been mentioned before, whether a company-wide policy is being challenged, or in a wage statement case. Look for cases where documents will not prove the violation at issue. Second, focus your discovery early on with the idea of sequencing in mind. Take the plaintiff's deposition early. Better than interrogatories that allow the plaintiff's attorney to craft the answers. Ask the plaintiff whether he or she has knowledge of any other violations in any other department or any other location. Chances are they're not going to. If they do, what is that knowledge based on? Is it hearsay? Is it inadmissible? Establish through discovery that the case cannot be proved without individualized testimony. Meal and rest period cases are a perfect example. Most of those will involve the plaintiff alleging, well, the time records will show the violations. They'll show if my meal period was late. They'll show if my meal period was short. Well, that doesn't prove a violation. That does not prove that the employer didn't provide the meal period, which is the standard under the code. And it doesn't prove that the plaintiff chose to take a late meal period or maybe voluntarily took a short meal period. So the wage and time records won't show violation in that case. Same with an off-the-clock work case like Elizabeth mentioned. So those are the prime kinds of cases that are ripe for sequencing motion. So individual testimony would be required in those cases. Those are the kinds of cases that are ripe for sequencing. Third, show your judge how unmanageable a trial of all aggrieved employees in California would be. There's a lot of federal district court cases that talk about unmanageability of PAGA cases in these contexts, and those are all persuasive authority in California courts. So use those cases to your advantage. Emphasize to your judge that you're not asking the court to prevent plaintiff from getting discovery. You're just asking the court to possibly delay their right to get that discovery for all California employees, contingent on whether they can establish they personally have suffered a labor code violation. It's not unfair or unduly prejudicial to ask that the plaintiff prove their case before they get that discovery. So the plaintiffs will be pounding the table, saying that Huff and Williams guarantees their right to this discovery, this broad discovery. No, they don't. As discussed above, those cases are not relevant to sequencing. Point out that the plaintiff is not going to be burdened by this. It really, in the long run, is cheaper and less time-consuming, not only for the defendant, but it's cheaper and less time-consuming for the plaintiff as well. Ask the court to ask the plaintiff, how are they prejudiced by sequencing? How are they prejudiced by having to prove their case first? Chances are they're not going to be able to come up with a credible answer. We know the real answer is because they want as much fees as possible, but they're not going to be able to say that in court. So more likely they'll be like the plaintiff's attorney in my case, where Judge Chow turned to her and asked, how are you prejudiced by this? And she just stammered and said, but Williams says we get this discovery. So that was the only thing they could do. And Williams doesn't give them that discovery. So then I think we're on the final slide. Another thing to think about is start thinking about sequencing as soon as you get your judicial assignment. A lot of times your judge can be key. In our case, we were initially assigned to Judge Wiener in San Mateo County Superior Court, and if any of you have familiarity with her, you know that she will not limit discovery in any PAGA case ever. We 170.6'd her and got assigned to Judge Chow, who ended up granting our sequencing motion. So that's a perfect example of where a 170.6 motion can be key. Another example we found is Judge Belaire in Monterey, very plaintiff-oriented, another target for a 170.6 motion. Anecdotally, and maybe surprisingly, we found that Los Angeles Superior Courts tend to be a little more receptive to sequencing and phasing motions, along with Santa Clara and sometimes San Francisco. Other courts like Contra Costa and Alameda, much less of a tendency to grant these motions. So at the outset, research your judge. Ask your colleagues if they've had prior experience. A lot of Superior Court decisions are available on Lexis now. Research those, look at those. And don't be afraid to use a 170.6 motion. Also, if you find that discovery is getting out of hand, think about using a discovery referee. That also might help get a different viewpoint as to sequencing and phasing if you're stuck with a bad judge. So those are some things to keep in mind.
Thank you, everyone, for attending today's PAGA webinar. I have up on the screen the remaining 3 sessions of the series. The next one is scheduled for October 13th, and we hope to see you then. Thank you so much for participating in today's webinar.